Great. Today's topic is to discuss Connecticut paid leave, particularly focusing on the impacts and effects of Public Act 25-174 on schools, which means that we really need to talk about Connecticut paid leave and Connecticut FMLA and what schools are doing. We will have time for questions. We have an appendix of materials that we will share that we think we probably won't have time to get through today, but we want to just give you that background. We are also going to be offering webinars on just general information about Connecticut paid leave and Connecticut FMLA that will supplement today, so be on the lookout for those. Just to make sure everyone is in the right place, today's webinar is focused on non-public elementary and secondary schools. If you are a public school operator, you are welcome to stay. We do have webinars geared for public school operators. Just so that everyone knows what term we're talking about, public school operators is a new term. It's part of Public Act 25-174. It's a more comprehensive definition of public schools. Public school operator is defined as local or regional boards of education. We include RESCs in this because they are comprised of regional boards. It also includes interdistrict magnet school operators, state or local charter schools, as well as endowed or incorporated academies approved by the State Board of Education pursuant to 10-76D. This is italicized because those academies approved pursuant to 10-76D tend to relate to special education programs. Some of those programs may really consider themselves to be private schools, but the legislature considers you to be a public school operator. It's okay, you can stay. And then there's always the cooperative arrangements pursuant to sort of regional arrangements pursuant to 10-158A. If you are a public school operator, again, you're welcome to stay, but we're really going to be focusing on non-public elementary and secondary schools this morning. We really consider the difference to mostly be about whether or not you are likely to have any positions that require certified teachers. So let's talk about Connecticut paid leave from a high level. The Connecticut paid leave program is a worker-funded program for workers by workers. Our act was originally signed in 2019, which created a source of income replacement benefits for eligible workers who need time off from work for qualifying reasons. As I mentioned, this is a worker-funded program. Employers do not put in any money into this program. Instead, those covered employers deduct 0.5% from their workers' paychecks up to the Social Security limit. We call these the contributions. Employers remit the contributions to the paid leave authority on a quarterly basis. The contributions are then pooled into a trust fund, and we use that money to pay benefits. So if a worker needs to take time away from work for a qualifying reason, they're sick, they're caring for a family member who's sick, and any of the other reasons, they apply to their employer for job-protected leave under the FMLA, Federal or State Family and Medical Leave Act. But they can apply to the Connecticut Paid Leave Authority to receive money while they're away from work. We have been providing benefits since 2022, and over 165,000 Connecticut workers have received benefits in that time, totaling over $1.2 billion. We have received claims from every corner of the state, so if you are new to the paid leave program, you got to avoid some of the sort of early stages where it was a little bit rocky, so you've got us up and running. So congratulations, we're happy you're joining us. I'm going to say this a lot, but I'm going to start now. FMLA and Connecticut paid leave are not the same. These are two, technically three, separate laws. FMLA provides job-protected leave. There's actually a federal FMLA and a Connecticut FMLA. The Connecticut FMLA was also amended by Public Act 25-174 to include employees of schools who are in positions that do not require certification. The thing to know about FMLA is that these laws allow eligible workers to take unpaid job-protected time away from work. These laws are implemented by the employer, so you are the one processing the leave request. and they're regulated by the state and federal departments of labor. Both laws say that the leave is unpaid. However, an employer can permit or require their employees to use available PTO. But there is no obligation on the employer's part to pay the employees while they're out of work. That creates a gap, right? So people need time off from work. They have that job protection so they can go back to work when their need for leave is over. But it's hard to go for weeks at a time without an income. And that's where Connecticut paid leave comes in. We were created to fill that gap by creating a source of income replacement benefits. It is not a separate source of job protected leave. We're just the money. And by we, I mean the Connecticut Paid Leave Authority, which is a quasi-public state agency that is responsible for running this program. Connecticut paid leave is also different from Connecticut paid sick days. Connecticut paid sick days are sometimes referred to as paid leave. We try to discourage that because it causes confusion. We really do focus on paid sick days versus paid leave. The Connecticut paid sick days law has been around for a very long time, but it applied to only a small sector of the Connecticut workforce until last year. In 2024, lawmakers passed Public Act 24-8, which amended the paid sick days law to cover more workers. Basically, at the end of a roll-in period, anyone with more than one worker will eventually be covered. Depending on the size of your school, you may already be covered or you might be covered in the next year or two. This is a law which says, hey, employers, you need to provide a minimum of 40 hours of paid sick time to your employees if they work for you on a full-time basis. If they work part-time, it's prorated. These paid sick times or this PTO is funded by the employer, and it can be used for routine illnesses, cold, flu, ear infection, poison ivy, by the employee or their family member. It's really establishing that minimum, hey, you need to give some PTO to your folks. In 2025, as part of this latest bill, the law was amended to say that for boards of education and municipalities, they can look to their collective bargaining agreements to establish the rules about how this paid sick time can be used, specifically regarding the increments of usage. Okay, so paid sick days are the PTO that you as an employer have to give to your employees. It is separate from Connecticut paid leave, which again is employee funded and generally speaking, used for more serious conditions than paid sick days are. You know, paid sick days are usually the lower level stuff because you have to use those first. Paid leave is really here for the serious health condition. We have resources on our website to help show the difference, and the Connecticut DOL also has information on their website with much more detailed FAQs and examples of how paid sick days work. All right, let's talk about Public Act 175 and what it does with schools. If you go to Public Act 175, you will see that it's an incredibly long bill and deals with all sorts of things that probably don't matter to you unless you're looking for bond funds. But at the very end of this Public Act, there are several sections that relate to schools. It establishes that definition of public school operator that I referenced before. It mandates that employees of public school operators and non-public elementary and secondary schools who are not required to be certified will be covered by Connecticut paid leave and Connecticut FMLA. It allows the Connecticut Paid Leave Authority the discretion to account for alternate pay calendars when determining eligibility and benefit. We'll talk about that in a minute. And it establishes a separate eligibility requirement for school employees under Connecticut FMLA. So let's break that down a little bit. Starting on October 1st, 2025, the population of covered employers will expand to include those public school operators, but only as to employees whose positions do not require certification under Chapter 166, as well as non-public elementary and secondary schools with respect to those employees whose positions do not require certification. If you are a non-public school and you have teachers who happen to have certification, but you didn't mandate that certification as a requirement, those teachers are covered. If you are a school and you do require certification for certain positions, you will have to exclude those people from participation. So that's going to be something you will want to look at your roster of employees, check to see if any of them require certification. Anyone who does is going to stay out. Anyone who does not is in. Similarly, the Connecticut FMLA was revised to include individuals who work for schools whose positions do not require certification. Okay, we know that some schools allow some employees the option to select among multiple payment schedules. Really, we're talking about folks who work during the school year and are given the opportunity to say, hey, I want to be paid over 10 months, or maybe I want to be paid over 12 months, or maybe it's 10 months plus a balloon payment in June. That gives great flexibility to your employees. But it creates some anomalous results for purposes of Connecticut paid leave because we look at quarterly wages when we determine eligibility and benefits. And if you have two people in the same job who both work from, August or September to May or June, making the same salary, but one picks that they want to be paid over 12 months and the other picks they want to be paid over 10 months, if we just let that be, it would have an anomalous result. And that's not fair. We want to make sure that people are treated equitably. So we will be asking, is this employee who's filed for us given the option to select among different payment schedules? And then if that is the case, then we will determine their quarterly wages simply by dividing their annual wages by 4. So we don't have those anomalies. This is a proposed rule. It is published in the Connecticut Law Journal. It's also published on our website at ctpaidleave.org. If you have concerns about this proposed rule, or if you think it's a great rule and you want to tell us that, you can reach out to us and let us know. The contact information for reaching out to us is also included on our website. And actually, we can throw that in the chat as well, so you have that information. We will be receiving comments until August 22nd, and then asking our board of directors to approve this rule, which will create it essentially as the force of a regulation in September, in advance of the October 1st start date. Final change that was related to 25-174 relates to Connecticut FMLA. Under Connecticut FMLA, in order to be eligible for the job protected leave, most employees have to show that they were employed by that employer for at least the 3 months immediately preceding the leave. If that remained the case for school employees, nobody would be able to take leave in September because they would have been out of work, still employed potentially, but maybe they just got hired, or maybe they were off the previous semester, or any of those situations. So they wanted to just sort of recognize some of the difficulty of folks being off payroll in the summertime months. So slight change for Connecticut FMLA. You have to have been employed for at least 3 months during the previous 12-month period, right? So it's just look back at the 12 months before they start leave. Were they employed for at least 3 months cumulative in that period of time? Okay, so now we've talked about who's covered under Connecticut paid leave and Connecticut FMLA and some of the nuances of the law. What does that mean for you going forward? Well, for Connecticut paid leave, there are two elements to our program. There's the contribution side and the claim side. Contribution side we've talked about already. The employees have to contribute 0.5% of their wages, and we use the same definition of wages as FICA does. But the employees don't pay us directly. This is a payroll tax. So the employer needs to register with us at ctpaidleave.org, deduct that 0.5% of the wages, and then remit them to us. If you use a payroll provider, Paychex or ADP or whatever, they're very familiar with Connecticut Paid Leave. They've been doing it for a while now, but you need to probably follow up with them and just say, hey, look, we're in it too. And just double check to make sure that they're doing it properly. We receive those contributions. We will reconcile them. If there are any over or under payments, we'll take care of that. We do impose penalties for non-compliance, and the penalties go to the employer. First, if the employer fails to take that deduction from the employee's wages, the obligation falls to the employer. So even though this is meant to be an employee-funded program, the employer is responsible for making sure that the deductions happen. And if that doesn't happen, now the money has to come from the employer. So compliance is important. In addition to that, we do have authority to impose interest and a fine for non-compliance. So how do you register with us? Well, you go to ctpaidleave.org. Excuse me. And look at the how to register as an employer page on our website. A couple of things specifically important for schools. When you register, you will be asked to select your business type. You will pick the appropriate type. For most people on this call, it will be the non-public elementary or secondary school. If you are a public school operator, you're going to say you're covered, you're registering as a PSO in connection with your non-certified employees. Public school operators, as well as municipalities, have an element of the statute that we're really not getting into today, which is that your unionized employees who are not otherwise covered by the law can collectively bargain in. And if that ever happens, then they would notify us and re-register to cover their full workforce, showing that they're participating through a collective bargaining agreement. We do ask for additional information when you register. It's not a whole lot, but it'll take you about 5-10 minutes to do it. One of the things we ask is, what is the date you first had Connecticut workers? This information is used to determine when the contributions are owed. So you may have been teaching Connecticut students for the last 100 years. Please don't put that you've been in existence since 1925. Just put the date that you become covered. So for most of you, this will be October 1st of 2025. If you were a public entity that participates through collective bargaining agreement, you would enter the date of that agreement. When you register, you are going to have access to information about your organization on the contribution side. So it's going to tell you, have you submitted the contributions? What contribution, did the contribution payment go through? It does not give you information about the claims, but a lot of employers want some information about their employee claims. When an employee files a claim with us and they get approved, we do notify the employer. We send them an email, but we have been hearing from employers that they would like a report that shows all of their employees. So we have that now, but only authorized representatives for the employer can access this information. You will get information about the employee claim, the case number, whether it was approved or denied, and if it was approved, you get information about the dates of the claim and the benefit amount. You do not see the whole case file. You do not see the medicals. It's just very basic information about the claim. So if this is something that you would like to have, you would complete the employer claim access form. The instructions are found on our employers tab. You have to validate for us that you are somebody who has the right to accessing this information. So it's additional step beyond just sort of registering your organization. You may have a payroll person who's perfectly fine to do contributions, but you don't want them to see which employees are out on leave. That's why we have this separate step. Okay, as I mentioned, once you register, you would contribute. We do it on a quarterly basis. We do have a 1 month grace period, so you're not going to get hit with any penalties or fines if you make your payment within that 1 month grace period. And then there's the claim side. Most of the work for CT paid leave claims falls on the worker and the paid leave authority with our claim administrator, AFLAC. So the worker would file their claim with us directly, online or by calling. There is documentation they have to provide to us. They are required by law to notify you, the employer, that they have filed a claim. You, the employer, cannot refuse or to allow them to file a claim. That's not allowed. You are in charge of FMLA. You're not in charge of paid leave. But they do have to let you know. When they file a claim with us, we will be giving them a form to give to you. It's a special employment verification form. We are creating one specifically for schools so that we can validate, are they in a position that requires certification, and are they being paid kind of based on a no choice schedule, or were they given the choice of the calendar by which they get paid? So you will complete that employment verification form. You will also let us know if there are any school holidays or shutdowns that we should be aware of. This is sort of basic FMLA rules and basic paid leave rules. You don't get leave if you're not scheduled to work. You don't get benefits if you wouldn't have been scheduled to work. So a person who needs hip surgery in July and they weren't scheduled to work in July can't get benefits from us. And so that's why we need to know when somebody is scheduled to work. So as the employer, you would complete that form. You are also required to let your employee know about your PTO policies. Do you offer paid time off? Do you offer short-term disability? What does that short-term disability policy say? And of course, you cannot discriminate or retaliate against your worker who's filing a claim or interfere with that ability. So you complete the form. You can either give it back to your employee or you can send it directly to us. We, with our TPA, AFLAC, will review the documentation. We determine the eligibility. We either approve or deny the claim and pay the benefits. If we deny a claim, we notify the worker as to the reason for the denial. They do get an opportunity to request reconsideration, but the worker could also file an appeal to Department of Labor, and they will hear the case. So, as I said, Connecticut paid leave, not that much for you to do. FMLA is where you will be doing most of your work in this world. The relationship on an FMLA claim is really between the worker and the employer. So the worker is going to say, hey, I need that hip surgery and I really need to take it next month. What do I need to do? So you need to have a policy. If you are already subject to federal FMLA, you can just sort of expand it to include Connecticut FMLA. If you've never been subject to federal FMLA, I encourage you to check out the DOL website, either the Connecticut or the federal. They both have lots of great information. They will help you establish policies and the forms that you want so that you can let your employees know what to do. They will submit the documentation to you. You will review it, determine if they're eligible, approve or deny, and then make sure that you're tracking their time so that you know how much time they've used and how much time they have. Employees are required to provide you with documentation. It has to be reasonable. You don't get the entire case file, but you do get a mid-cert, right? And they are supposed to comply with your attendance and call-in policies. Connecticut DOL and the federal DOL both have a wealth of information on their websites, and we will share that with you at the end of the slides. So what should you do as a newly covered employer under Connecticut FMLA? Well, make sure you have a leave policy that acknowledges that you are newly covered. Make sure that you are clear about your rules regarding PTO. As I mentioned earlier, FMLA is unpaid, but an employer may permit or require their employees to use their PTO. There is one important caveat to be aware of. Connecticut FMLA says that an employer cannot mandate that their employees exhaust all their PTO when they're out on Connecticut FMLA leave. Instead, the employee must be given the option to hold up to 2 weeks of PTO for a different purpose. Right? So if you offer your employees only 2 weeks of PTO, then you cannot mandate that they use it. If you offer your employees 4 weeks of PTO, you can say, hey, 2 weeks have to be used for your FMLA reason. The other 2 weeks are up to you. So it's important to know about and then be clear about in your policy. There are posters that you can find on the DOL websites that you want to post to make sure your employees know what the rules are. It's important that your workers understand they need to let you know what's going on, right? They have to provide notice. They have to let you know when they're out and the reason that they're out, and they have to provide you with medical certification and appropriate documentation. But they don't have to turn over their entire medical history to you. And they certainly can't be held to higher standards than your regular attendance policies. Okay, before we sort of stop sharing and I can look at the questions that have been coming in, let's just talk a little bit about the basics. I've been talking about covered leave reasons. It's good for you to know what those covered leave reasons are. The first, and it's first because honestly, this is about 50% of the reasons we see people taking leave, is for their own serious health condition. The definition of serious health condition statutorily includes serving as an organ or bone marrow donor. It also includes pregnancy and recovery from childbirth. We treat those two reasons as separate, but technically they fall into the bucket of medical leave. Then there's bonding leave. Bonding leave is leave that is available to the parents of a newborn child, a newly adopted child, or a newly placed foster child. Both parents or either parent can use this. The definition of parent includes the biological, adopted, or foster parent. It also could include a step parent. It could include really anyone who is in loco parentis, standing in the place of a parent to the child. So there doesn't have to be a formal legal relationship. If there is a person in this child's life who is going to be raising that child, they are the parent, they can bond with the child. Bonding leave is unique amongst the leave types because the timing is sort of in the discretion of the worker. You can use bonding leave anytime during the 12 months after the birth or placement. Then we have caregiver leave. Caregiver leave is leave that a worker would take because they need to provide physical or psychological care or comfort to a family member who's experienced a serious health condition. This could look like taking that family member to doctor's appointments, or being with them when they're in the hospital, or staying at home with them because it's not safe for them to be at home. Think about a small child who's recovering from a broken arm. They can't stay at home alone. So that's caregiver leave. There are two types of military family leave that are important to be aware of. Even though we don't see them a lot, it's still necessary to know about them. There's military caregiver leave, where you care for a family member who was injured or became ill in the line of duty on active duty in the armed forces. You get more leave under FMLA for military caregiver leave. That's really the biggest difference. Then there's qualifying exigency leave. This is leave that a parent, spouse, or child can take to address certain situations that arise from the fact that the employee can take because their parent, spouse, or child has been notified of a call to duty or is on active duty. So say you have an employee whose spouse is notified that their National Guard unit is going to be deployed to Afghanistan. That employee is going to be like, I have a lot to do. I might have to update my will. I might need to update my banking arrangements. Maybe I need to find alternate childcare because my spouse is the one who's been home with the child, and now I need a little bit of time to coordinate new childcare. There are 9 qualifying reasons that count for qualified exigency leave. Those are all on our website if you're new to it, but it's important to know it's there. And then finally, there's the Family Violence Leave Act. This is technically in addition to FMLA. It's actually found at 3151 SS of the Connecticut General Statutes. Family Violence Leave Act says that an individual who is the victim of family violence or sexual assault can take up to 12 days in a calendar year of job-protected time off in order to obtain medical or psychological care or counseling, to obtain services from a victim services organization, to relocate if that's necessary, or to participate in a civil or criminal proceeding related to the incident. The Family Violence Leave Act has been on the books for 15 years, and it has always applied to schools. It applies to employers with 3 or more employees. The only thing that has changed is that it now applies to sexual assault as well. But if a person in your school needs this Family Violence Leave Act, they can apply to us at the Paid Leave Authority for money to help them pay the bills while they're out of work. Couple of additional points to just focus on. Serious health condition is meant to be serious, right? And so how do the laws define seriousness? Well, they talk about both being incapacitated, meaning you can't go to work or you can't go to school, and needing treatment from a healthcare provider. Some of the examples are a person who has an overnight stay in a hospital, a person who has a chronic condition for which they need treatment from a healthcare provider at least 2 times a year. It could be a long-term condition where treatment may no longer be effective in the sense of we're not expecting a cure, but they're still under medical supervision. And as I mentioned before, incapacitation during pregnancy counts as a serious health condition. That could be just the regular prenatal appointments, or it could be the complications during pregnancy. The other thing to be aware of is the definition of family member under Connecticut law. Family member under Connecticut FMLA and Connecticut paid leave is broader than the definition of family member under federal FMLA and broader than it used to be under Connecticut FMLA prior to 2022. Federal FMLA says you can only use the leave to care for a parent, spouse, or child who is under 18 or 18 and older who has a disability as defined by the Americans with Disabilities Act, which prevents that person from engaging in 3 or more activities of daily living. So, relatively small population of people for whom you could take caregiver leave under federal law. Connecticut law says you can take caregiver leave and receive benefits to care for your parent or your spouse, your son or daughter of any age, as well as the sibling, grandparent, or grandchild. It also allows you to take leave and receive benefits for your chosen family. The statute defines or uses the term a person who's related by blood or affinity. And they say it's a person with whom the worker has a significant personal bond that is like one of the family relationships that I just listed. And you don't need to have a biological or a legal relationship. This is fact specific, but really it comes down to the individual should be the person who decides whether the loved one is a family member, not the state and not the employer. We see about 3% of our caregiver claims involve related by affinity. And our caregiver claims are about 15% of our overall claims. So it's a really small number, but for the people who need it, they really do need it. Connecticut is a state that does not recognize common law marriages. So if Kurt Russell and Goldie Hawn lived in Connecticut, we would not consider them to be married. And without this related by affinity, if Goldie got sick, Kurt would not have any legal rights to take care of her or get benefits. Until now. Related by affinity says, yes, they are in a long-term loving relationship. That counts. Other examples could be that aunt or uncle who is the equivalent of a sibling or parent. In my family, my great aunt really had the role of a grandmother to me. That would count. So just be aware that we do have this chosen family definition that is important for your employees to know about. Okay, other things you should know. We have 3 different types of leave that people can take. Block leave is what most people think about. Block leave is when you're taking leave for a continuous period of time for a single qualifying reason, right? The surgery, the bonding with a newborn baby. I start my leave on September 1st and I'm coming back on October 15th. That's not the only way people take time. They could take time as a reduced schedule. So maybe they need physical therapy. Maybe they're going in for radiation treatment. So instead of working 9 to 5, Monday through Friday, they have to leave early. Or instead of starting work at 8 a.m., they have to start work at 8:30. That is allowable under FMLA, and we will make benefit payments to account for that reduced schedule. And then there's intermittent leave. Intermittent leave are those short periods of time that arise sporadically. Maybe you've got a chronic condition with flare-ups, and so when there's a flare-up, they need to take time off. Maybe they're serving as a caregiver, and they just need to take someone to the doctor's appointment. All 3 are available. All 3 need to be managed. The duration of leave for almost all of the leave reasons is 12 weeks in a 12-month period. As I mentioned before, a worker could get an additional 2 weeks for incapacity during pregnancy, which includes prenatal appointments. So if you have a worker who's pregnant and having a baby, they could technically get up to 14 weeks in a 12-month period. For that military caregiver leave, it's 26 weeks of job protected leave, although we at the authority can only pay 12 weeks of benefits. And then finally, that safe leave for family violence or sexual assault under Family Violence Leave Act is capped at 12 days. All right, we're going to take some questions now, but I want you to have this slide, take a picture, we'll share it with you. If you have questions that you think of later, I encourage you to check out our website at ctpaidleave.org. We have a lot of information. We've got videos, we've got fact sheets, we've got Q&As, but if you still can't find your answer, go to our Contact Us page and submit your question. If you have an employee who, in the future, once they become covered, it's like, gosh, I just don't know what to do about my claim, and you want to be helpful to them, you can say, hey, yeah, I know what to do. You should go to your portal and check out your account, or you can call AFLAC directly. If you have questions about Connecticut FMLA, we want you to go to Connecticut DOL. They have a whole page that you can check out, and they also have a dedicated phone number and email address. And then the federal FMLA also has a really great resource on the DOL.gov website